Mr. Chair. Mr. Chair.
Mr. Chairman.
I call the honourable member, the Reverend David Clark.
Thank you, Mr. Chair.
Or the Reverend Dr. David Clark.
Mr. Chair, I rise to speak to this bill, and I want to start by first agreeing that with the previous speaker that the Y262 matters need to be addressed. I mean, I think that is fundamentally something that this government has been very slow to work on, and Māori that I speak with who have an interest in this area are incredibly frustrated with the lack of progress on that particular claim. And there are some very tricky details to sort through, there is absolutely no doubt, but that is no excuse for not addressing them, for parking the work and not actually getting on with having that conversation. And it's my understanding that that is the current state of things. The Minister and the Chair may like to take a call to correct me if that is not the case, and maybe explain what work is going on, because it does cut to the heart of the issue that we are debating here, and to which I wish to return as I round out my contribution on this part of the bill. This part of the bill is, as I said, right there at the core. I mean, it starts out, a patent may be granted for patentable inventions only. Now, in one sense we would say that is an absolute truism, but then this part of the bill wants to set out what that means and what it doesn't mean, because we need to know as lawmakers exactly why we are putting these things in place and what the purposes we're trying to achieve. We talked about the wider public and social good in the previous section. Well, this part of the bill lays out exactly what it is that means, Mr. Chair. There are many types of intellectual property. When we're talking about patents which protect ideas and concepts as opposed to designs which protect appearance aesthetics and the like, and copyright which protects things, the copying, things that are exactly the same, or trademarks which are designed to protect a unique sign. And it's distinguished from know-how, which is more around confidential information, the kind of thing that is usually covered by contracts. So we're talking here about patents and what is patentable. And there is a significant change that is picked up in this part 2, clause 13. An invention which is patentable is one which is a manner of manufacture, is novel, takes an inventive step, that means it's not obvious, is useful, and is not excluded by other clauses that are discussed elsewhere, clause 14 and 15. Now, all of these criteria must be satisfied before a patent application can be accepted and granted. And currently, inventive step and usefulness are not part of the patent examination process. So this here tightens up the law in a fashion that we think is very important, but we don't go as far as to say that we think organisms, including plant varieties and traits in organisms, are not patentable inventions, and that is because of the kind of economy which we believe there should be in New Zealand. Now, I should say that all members of the House, or at least most parties, I believe, are going to be supporting this bill, if not all. So we are all in agreement that we need to have patentable material, and it needs to be well defined in the interests of New Zealand. What we're debating about, in one sense, is precisely how far this patenting should extend. And the Labour Party has a strong view that we need a diversified economy, that we need an economy that is based on new technologies, new inventions, new ideas and concepts. And so we want to support legislation which encourages new patents, that encourages new inventions, that encourages and protects the ideas generated by New Zealanders for greater social good reasons, but also in the interests of New Zealand as a country. So that's why we support the legislation, and that's why we think these tests need to be put in place. Now, the idea that we won't protect plant varieties, as suggested in SOP number 124 that Mr Browning has put forward, does potentially undercut the future prosperity of New Zealand. In the Labour Party, we believe that we need to have a prosperous and flourishing economy in order to provide those social goods and in a sustainable fashion that we as a country would like to afford and need to afford. We see at the moment, with high unemployment and an economy that's struggling, many of these things being cut through a range of cuts by the government. Mr. Chair, and Mr. Chair,
Honourable Member, Dr. David Clark.
and in order to afford the healthcare and the education that we as a country would like to see, we need to have a prosperous economy. And one way in which we do that is by protecting intellectual property correctly. So a law which updates the understanding of what that might mean is very important to New Zealand's future prosperity, to a diverse economy that is not susceptible to being putting all our eggs in one basket and then susceptible to global trends on commodity prices, to use one very pertinent example right now with the trade issues with China. This kind of legislation can encourage entrepreneurs to explore new ideas, to expand the base of human knowledge, and therefore to also increase New Zealand's prosperity over time. Now, there are exclusions which are explicit in this part of the bill, and we support these as well. And the examples provided here and in the SOPs, in several of the SOPs, are intended to give a signal to law interpreters further down the track. And so, for example, we know that exclusions are there to restrict access to necessary health care, to treatments of human beings by surgery or therapy, to methods of diagnosis practiced on human beings, and to biological processes for their generation in respect of human beings. There are others that are here as examples, obviously intended as a guide to, if we look at number 14, subclause 1b and beneath, we have a series of examples which are designed to suggest a more general principle. An invention is not patentable invention if the commercial exploitation of the invention, so far as claimed in a claim, is contrary to public order or morality. And these are things that we would consider amoral potentially in that list. So, Mr. Chair, those kinds of exclusions are put in there for good reason. They are technical exclusions, but they are very important and intended as a guide for future use. This part also defines the term of a patent, which is 20 years from the patent date, unless certain fees are not paid that are appropriate to the filing of a patent. And the purpose of a patent is to enable the inventor to exploit the invention, obviously to encourage them to invest and therefore reap a reward further down the track. The various, what shall we call them, protections is the right word, put around that throughout Part 2 are there to make sure that those things are looked after. Subpart 3 is about who may be granted a patent and covers technical details around co-owners of patents, because we know that once you add a few more people into the mix, these things can become more complicated. And it's good that the department has worked through the detail in that respect, and also gives a power to a commissioner to give directions to co-owners. So there's a discretion clause in here, that clause 25 there under Part 2, Subpart 3, which gives the Commissioner some discretion, and that seems appropriate in the context of this legislation so that we don't get perverse outcomes from the legislation. But we in the Labour Party, to round out this contribution, are uncomfortable, very uncomfortable with the exclusion of organisms, especially considering the way in which some of our more prosperous inventions have been come from that area, for example in the kiwi fruit industry, as alluded to by my colleague Dr. Megan Woods earlier on. And we know patents such as the Hamilton Jet and so on are the trademark, not the trademark, excuse the pun, are the hallmark, thank you to the Honourable Marion Street for that tip, the hallmark of a New Zealand that we would want to see going into the future. It's that kind of inventiveness that our very good education system has produced. We produce quality graduates who are smart thinkers. We want to ensure New Zealand's prosperity is built on that creativeness. I am looking forward to a contribution from the Minister, because this is a very important issue for this bill as to whether these inventions are excluded or included, and I'm interested in his view on this matter. He's been strangely quiet, perhaps a member of that rare species of parliamentary wallflower that the public would happily have us patent, perhaps, in order for more widespread exploitation. But I'm sure the Minister will take a call, and I look forward to hearing why it is that he thinks the supplementary order paper should be excluded or excluded. Thank you, Mr. Chair.
I call the honourable member Dennis O'Rourke.
Thank you, Mr. Chairman.